Okay, I suppose I'm going to read the Code of California Code of Civil Procedure. Trying to get the girl to read it, but she won't. So we're going to start with the preliminary provisions, part 1 of Courts of Justice, which is really long. It says 35 to 286. Are the sections. Doesn't seem to want to open. Neither does Title I, Organization and Jurisdiction. So we go to Chapter 1, which is titled Courts of Justice in General. 35, Section 35. Proceedings in cases involving the registration or denial of registration of voters, the certification of or denial of certification of candidates, didn't know I was reading this. The certification or denial of certification of ballot measures, election contests, actions under Section 20010 of the Elections Code, and actions under Chapter 2 commencing with Section 21100 of Division 21 of the Elections Code shall be placed on the calendar in the court of the date of filing and shall be given precedence. Part B, under 35, this section shall remain in effect only until January 1, 2027, and as of that date is repealed unless later enacted statute that is enacted before that date deletes or extends that date. There's another section 35 here, 35A again, which, just reading myself, it again has to do with ballots and elections. And I'm going to assume it's there because of being a priority on the court's calendar. So moving to Section 36, a party to a civil action who is over 70 years of age may petition the court for a preference which the court shall grant if the court makes both of the following findings. 1, the party has a substantial interest in the action as a whole. 2, the health of the party is such that preference is necessary to prevent prejudicing the party's interest in the litigation. B, under 36, a civil action to recover damages for wrongful death or personal injury shall be entitled or preference upon the motion of any party to the action who is under 14 years of age unless the court finds that the party does not have substantial interest in the case as a whole. That's all the light we get. All right, what else? A civil action subject to subdivision A shall be given preference over a case subject to the subdivision, unless the court otherwise orders. 1, and this is part C, this is subsection C, unless the court otherwise orders. Subsection C, that is, this could probably be unplugged. 1, a party may file, so unless a court orders that a party may file and serve a motion for preference supported by a declaration of the moving party that all essential parties have been served with process or have appeared. And 2, at any time during the pendency of the action, a party who reaches 70 years of age may file and serve a motion for preference. Part D, in its discretion, the court may also grant a motion for preference that is accompanied by clear and convincing medical documentation that concludes that one of the parties suffers from an illness or condition raising substantial medical doubt of survival of the party beyond 6 months, and that satisfies the court that the interest of justice will be served by granting the preference. So again, this just has to do with preference. And I have a California overview, civil procedure. And we really don't have anything speaking to Title I, Chapter 1 regarding preference. for elections and older Americans. So I'm just going to add that and see if we can't bypass some of it. Clear and convincing medical documentation. That's your burden of proof. What else? An affidavit signed by an attorney. Okay, in section 37, I feel that we've shifted into criminal felonies. So there's preference given to plaintiff's action. Unless the provision or context otherwise requires a reference in the statute to a judicial district, means as it relates to the Court of Appeal, the Court of Appeal district, and as it relates to the Superior Court, the county. All right, so that was chapter 1. So I have to learn how to navigate to the next section. Up, back. It's really not. Use the back button. Okay, chapter 3. So we skip chapter 2, and we skip actually 3 sections because chapter 3 starts with Supreme Court and Rule 41 through 45. 41, the Supreme Court and courts of appeal may transact business at any time. 42, adjournments from day to day or from time to time are to be construed as recesses in the sessions and shall not prevent the Supreme Court or the courts of appeal from sitting at any time. 43, the Supreme Court and the courts of appeal may affirm, reverse, or modify any judgment or order appealing from and may direct the proper judgment or order to be entered, direct a new trial or further proceedings to be had. In giving its discretion, if a new trial be granted, the court shall pass upon and determine all questions of law involved in the case presented upon such appeal and necessary for the final determination of the case. Its judgment in appealed cases shall be remitted to the court from which the appeal is taken. Appeals and probate proceedings, this is Rule 44, in contested election cases and in actions for libel or slander by a person who holds an elective public office or a candidate for any such office alleged to have occurred during the course of an election campaign shall be given preference in hearing in the courts of appeal and in the Supreme Court when transferred thereto. All these cases shall be placed on the calendar in the order of their date of issue, next after cases in which the people of the states are parties. And last rule in this section 45, an appeal from a judgment freeing a minor who is a dependent child of the juvenile court from paternity, custody, and control, or parental custody and control, or denying a recommendation to free a minor from parental custody or control shall have precedence over all cases in the court to which an appeal in the matter is taken, in order to enable a child to be available for adoption as soon as possible and to minimize the anxiety to all parties. The appellate court shall grant an extension of time to the court reporter or to counsel only upon exceptional showing of good cause. Okay. So I'm just writing down here the juveniles have preference, and so do I want to say electorates, but I don't know if that's the right terminology. That's a person running for office. So let me go back to the litany of chapters under Title I. And Superior Courts is Chapter 4. So Article 1 and 2, then there's limited civil cases, Article 1 and 2. Chapter 5 and that's 5.1. 5.5 is Small Claims Court, Article 1 through 9, General Provisions, Small Claims Court, Actions, Parties, Hearing, and Judgment. I feel like I could skip that, so I'll never be practicing in that setting. Did I say motion to vacate, appeal, and related matters, satisfaction and enforcement of a judgment, and administration? Might be worthwhile to look at the satisfaction and enforcement of judgment, assuming it's the same. So, before I go to Chapter 4, I just want to be aware there's a Chapter 6 and a Chapter 7. 7 is like special immigrant juvenile findings, and 6 is general provisions respecting courts of justice, open court access, incidental powers and duties of courts, judicial holidays, proceedings in case of absence of judge, and seals of courts. Those are just general provisions. Okay, so let's go to the Superior Court, Chapter 4, 71 through 77. 71, the process of Superior Court shall extend through the state. 73C, notwithstanding anything to the contrary contained in any other law of the state, the judges of the Superior Court of the county in which is located the principal office in the state of any savings and loan association of whose business, property, and assets possession shall have been taken by the Commissioner of Financial Institutions, not called that anymore, may, in their discretion, whenever those judges deem it necessary or advisable, hold hearings relating to the sale, exchange, or other disposition of any parcel of real property or any item of personal property of the association, regardless of the location of the property, at the county seat of the county in the state, or at the places in the county in which the principal office in this state of the association is located, at which sessions of the Superior Court are held. I totally understand every word of that. So sorry, I went fast. 73D, whenever under 73C, I just read, it becomes necessary for a judge, clerk, deputy clerk, court reporter, or bailiff of, or sitting in the Superior Court of the county in this state in which is located the principal office of any savings and loan association whose business, property, and assets are in the possession of the Commissioner of Financial Institutions, to travel. It's now called the Department of Financial Protection and Innovation, to travel to another county there temporarily to attend hearings related to the sale, exchange, or other disposition of real or personal property of the association. Each judge, clerk, deputy clerk, court reporter, or bailiff shall be allowed to the necessary expenses in going to, returning from, or attending upon the business of the court. The expenses shall, upon order of the court, be a charge against the funds of the association and paid out of those funds by the Commissioner of Financial Institutions. I mean, I know DPFI deals with fintech, but these are savings and loans, subchapter N. So perhaps there is a Commissioner of Financial Institutions that isn't DPFI. Anyways, 73E, notwithstanding any other provisions of law, in each county wherein the juvenile hall is not located at the county seat of the county, a majority of the judges of the Superior Court in and for such county may, by an order filed with the clerk of the court, direct that a session or sessions of the Superior Court, while sitting for the purpose of hearing and determining cases and proceedings arising under Chapter 2 of Part 1 or Division 2 of, or Chapter 2 of Part 1, doesn't exist, of Division 6, or Chapter 4 of Part 4 of Division 6 of the Welfare and Institutions Code may be held or continued in any place in the county in which the juvenile hall is located, and thereafter such sessions or sessions of the court may be held or continued in the location designated in such order in a county having 2 superior court judges. The presiding judge may make the order. And 74, it's weird how they for adjournments from day to day or from time to time are to be construed as recesses in the sessions and shall not prevent the court from sitting at any time. 75. The Superior Court in any county may by rule provide whenever all judges are absent from the county any non-contested matter in which no evidence is required or which may be submitted upon affidavits shall be deemed submitted upon the filing with the clerk of a statement of submission of the party or the party's attorney or upon the date set for the hearing. 77A. In every county, there is an appellate division of the Superior Court consisting of 3 judges, or when the Chief Justice finds it necessary, 4 judges. The Chief Justice shall assign judges to the appellate division for specified terms pursuant to rules not inconsistent with statute adopted by the Judicial Council to promote the independence and quality of each appellate division. Each judge assigned to the appellate division of Superior Court shall be a judge of that court, a judge of the Superior Court of any county, or a judge retired from the Superior Court or a court of higher jurisdiction in the state. The Chief Justice shall designate one of the judges of each appellate division as the presiding judge of the division. B. In each appellate division, no more than 3 judges shall participate in hearing a decision. A presiding judge of the division shall designate the 3 judges who shall participate. In addition to these in addition to their other duties, the judges designated members of the appellate division of the Superior Court shall, for the period specified in the order of designation, they shall serve for the period specified in the order of designation. Whenever a judge is designated to serve in an appellate division of the Superior Court of the county other than the county in which the judge was elected or appointed as a Superior Court judge, or if the judge is retired in a county other than the county in which the judge resides, the judge shall receive expenses for travel, board, and lodging. If the judge is out of the judge's county overnight or longer by reason of the designation, that judge shall be paid per diem allowance in lieu of expenses for board and lodging in the same amounts as are payable for those purposes to justices of the Supreme Court under the rules of the Department of General Services. In addition, a retired judge shall receive for the time also served amounts equal to that which the judge would have received if the judge had been assigned to the Superior Court of the county. The concurrence, this is D, of 2 judges of the appellate division of the Superior Court shall be necessary to render a decision in every case in and to transact any other business except business that may be done at chambers by the presiding judge of the division. Judgment of the appellate division in an appeal shall contain a brief statement of the reasons for the judgment. A judgment stating only affirmed or reversed is insufficient. The presiding judge shall convene the appellate division when necessary. The presiding judge shall also supervise its business and transact any business that may be done at chambers. E. The appellate division of the Superior Court has jurisdiction on appeal in cases in which the appeal may be taken to the Superior Court or the appellate division of the Superior Court as provided by law, except where the appeal is a retrial in the Superior Court. The powers of each appellate division shall be the same as are now or may hereafter be provided by law or rule of the Judicial Council relating to appeals to the appellate division in the Superior Courts. The Judicial Council shall promulgate rules not inconsistent with the law to promote the independence of and govern the practice and procedure and the disposition of the business of the appellate division. H, notwithstanding subdivisions B and D, appeals from convictions of traffic infractions may be heard and decided by one judge of the appellate division of the Superior Court. So, I believe that was chapter 4, because chapter 3 was about the Supreme Court, and chapter 4 is about the Superior Court. I'm just going to put like administrative. And appeal. Justices, because it didn't say much about granting like cert, if that is the terminology for appellate courts in California. Limited civil cases is chapter 5.1. It consists of Article 1, jurisdiction in limited cases, and Article 2 I didn't get to. This is a bit long, but only because it has a long list citing to other statutes. So section 85, that is, and once we pass through that, it won't be long. In fact, I think I'm going to skip it. So notwithstanding any law including but not limited to, and this is Rule 85, a law that classified an action or special proceeding as a limited civil case, an action or special proceeding shall be treated as a limited civil case only if all of the following conditions are satisfied. A, the amount in controversy does not exceed $35,000. As used in this section, amount in controversy means the amount of the demand or the recovery sought or the value of the property or the amount of the lien that is in controversy in the action exclusive of attorney's fees, interest, and costs. The relief sought is a type that may be granted in a limited civil case. All right, so we're talking limited civil cases. This is citation for this is like California Code of Civil Procedure, Part 1, Title 1, Chapter 5.1, limited civil cases. What I wrote here is problems between 5-10 through 25,000. So somehow the actual law is different than what, I don't know, Barbary thinks it is, because it's actually over 35,000. Am I right? Does not exceed. The amount of controversy does not exceed. So we're talking actually less than 35,000. So unlimited civil. I'm just going to cross out small claims. I don't even care about small claims. I've seen these people in action. Less than 35K. All right. So unlimited says greater than 25K in controversy. So yeah. Okay. So let's just read all this all over again. 85 says, notwithstanding any law, including but not limited to a law that classified an action or special proceeding as a limited civil case. An action or special proceeding shall be treated as a limited civil case only if all the following conditions are satisfied. The amount in controversy does not exceed $35,000. As used in this section, amount in controversy, I just defined that. It's the amount of the demand or the recovery sought or the value of the property or the amount of the lien that is in controversy in the action exclusive of attorney's fees, interest, and costs. The relief sought is, and so this is an and the relief sought is the type that may be granted in the limited civil case, and the relief sought, whether in the complaint, cross-complaint, or otherwise, is exclusively of a type described in one or more laws that classify an action or special proceeding as a limited civil case, or that provide that an action or special proceeding is within the original jurisdiction of the Superior Court, including but not limited to the following provisions. And you've got like the 700 series of the Civil Code, 1719 of the Civil Code, 3342 of the Civil Code. All right, so the Civil Code is like a relevant code. I guess that makes sense. Right, and that's why we're in civil procedure. There's section 86, 86.1, 17, 10, 20. Since there's no like other code cited, I presume that could very well be like what I am about to read in this chapter. And then there's a bunch of food and agricultural code citations, government code citations, public utilities code, vehicle code citations. So 86A, I'm guessing 86.1 might be what they're referring to. Yeah, might be what they're referring to. So let me just read this. An action brought pursuant to the Long-Term Care, Health, Safety, and Security Act of 1973, Chapter 2.4 doesn't exist anymore, commencing with Section 1417 of the Division 2 of the Health and Safety Code. Okay, so it's a different Chapter 2. Is a limited civil case if civil penalties are not sought or amount of $35,000 or less. So let's go back to 86 because that's one that's like specially giving jurisdiction in a limited civil case. 86A, the following civil cases and proceedings are limited civil cases. 1 through, we're going all the way down to 10. A case at law if the demand exclusive of interest or the value of property in controversy amounts to $35,000 or less. This paragraph does not apply to a case that involves the legality of any tax, impost, assessment, toll, or municipal fine, except an action to enforce payment of delinquent unsecured personal property taxes if the legality of the tax is not contested by the defendant. 2, an action for dissolution of a partnership if the total assets of the partnership do not exceed $35,000. Or an action of interpleader in the amount of money or the value of the property involved does not exceed $35,000. Interpleader, applying to the dissolution partnership. Interesting. Okay. 3, an action to cancel or rescind a contract if the relief is sought in connection with the action to recover money not exceeding $35,000, the property of a value not exceeding $35,000 paid or delivered under or in consideration of the contract, and action to revise a contract where the relief is sought in an action upon the contract if an action otherwise is a limited civil case. 4, a proceeding for forcible entry or forcible or unlawful detainer if the whole amount of damages claimed is $35,000 or less. 5, an action to enforce and foreclose a lien on personal property if the amount of the lien is $35,000 or less. 6, an action to enforce or foreclose a petition or release a lien arising under Chapter 4, commencing with Section 84,000. Title 2 of Part 6 of Division 4 of the Civil Code, or to enforce and foreclose an assessment lien or common interest development as defined in Section 41,000 or 6,534 of the Civil Code if the amount of the liens is $35,000 or less. However, if an action to enforce the lien affects property that is also affected by a similar pending action that is not a limited civil case, or if the total amount of liens sought to be foreclosed against the same property aggregates an amount of in excess of $35,000, the action is not a limited civil case. 7, an action for declaratory relief brought pursuant to either of the following. A, by way of cross-complaint as to the right of indemnity with respect to the relief demanded in the complaint or a cross-complaint in an action or proceeding that is otherwise a limited civil case. And B, under 7, an action for declaratory relief is brought pursuant to either of the following. B is the other alternative to conduct a trial after a non-binding fee arbitration between attorney and client, pursuant to Article 13, commencing with Section 6200 of Chapter 4 of Division 3 of the Business and Professions Code, if the amount in controversy is $35,000 or less. 8, under what is a limited civil action, is an action to issue a temporary restraining order, preliminary injunction to take an account, if necessary, to preserve the property or rights of any party to a limited civil case, to make any order or perform any act pursuant to Title 9, commencing with Section 680.010 of Part 2, Enforcement of Judgments in a limited civil case, to appoint a receiver pursuant to Section 564 in a limited civil case, or to determine title to personal property seized in a limited civil case. An action under Article 3 commencing with Section 708.210 of Chapter 6 of Division 2 of Title 9 of Part 2 for the recovery of an interest in personal property, or to enforce the liability of the debtor of a judgment debtor if the interest claimed adversely is of a value not exceeding $35,000, or the debt denied does not exceed $35,000. And 10, lastly, a limited civil action is an arbitration-related petition filed pursuant to either the following: Article 2, commencing with Section 1292 of Chapter 5 of Title 9 of Part 3, except for uninsured motorist arbitration proceedings in accordance with Section 11580.2 of the Insurance Code, if the petition is filed before the arbitration award becomes final and the matter to be resolved by arbitration is a limited civil case under paragraphs 1 through 9 inclusive of subdivision A, or if the petition is filed after an arbitration award becomes final and the amount of the award and all rulings, pronouncements, and decisions made in the award are within paragraphs 1 to 9 inclusive of subdivision A. And this is wait a minute, I just read 10. Okay, 10B says to confirm correct. 10 is an arbitration-related petition filed pursuant to the following: B, to confirm, correct, or vacate a fee arbitration award between an attorney and client that is binding or has become binding pursuant to Article 13, obviously somewhere in the Business and Professions Code, if the arbitration award is $35,000 or less. And in fact, actually, it's good to know. I'm just like writing down good to know things. Like, one, gotta go look at this civil code. 2, unlawful detainers are most likely limited civil cases. And 3rd, the Business and Professions Code, Chapter 4, relates to attorneys. Right? Chapter 4, Division 3, commencing. Okay. And then there's a little b under this section, following A. The following cases in equity are limited civil cases, it says. 1 through 3. 1, a case to try title to personal property when the amount involved is not more than $35,000. 2, a case when equity is pleaded as a defensive matter in any case that is otherwise a limited civil case. And 3, a case to vacate a judgment or order of the court obtained in a limited civil case through extrinsic fraud, mistake, inadvertence, or excusable neglect. 86.1, I read that. 87. A limited civil case may be brought in the Small Claims Division if the case is within the jurisdiction of the Small Claims Division as otherwise provided by statute, where a statute or rule applicable to the small claims case conflicts with the statute or rule applicable to a limited civil case. The statute or rule applicable to the small claims case governs the small claims case, and the statute or rule applicable to limited civil case does not. B, nothing in this section affects the jurisdiction of the Small Claims Division as otherwise provided by statute. 88, a civil action or proceeding other than a limited civil case may be referred to as an unlimited civil case. 89A, the existence of a statute relating to the authority of the court in a limited civil case does not by itself imply that the same authority does or does not exist in an unlimited civil case. And B, the existence of a statute relating to the authority of the court in an unlimited case does not by itself imply that the same authority does or does not exist in a limited civil case. So mainly, if the next section has to do with small claims, I wasn't going to read it, but before we get there, but I am going to read it, right? Because I want to know if it's like 10 to 15, 5 to 15, I don't know, under 25. Okay, unlimited says in my outline, unlimited civil cases looks like it's under 25,000 in controversy. And I think that's wrong. because it's saying whatever isn't limited is unlimited. So, like, I want to know where small claims fits in this. If small claims goes up to 35, then unlimited civil cases more than 35. Wait, something beneath 35. So economic litigation for limited civil cases, Article 2. It's actually pretty long because it goes between Rule 90 to like 99. So 90, except where changed by provisions of this article, all provisions of law applicable to civil actions generally apply to actions subject to this title. 91A, except as otherwise provided in this section, the provisions of this article apply to every limited case. B, the provisions of this article do not apply to any action under Chapter 5.5 commencing with Section 116.110 or any proceeding under Chapter 4 commencing with Section 1159 of Title 3 of Part 3. C, any action may, upon notice motion, be withdrawn from the provisions of this article upon a showing that it is impractical to prosecute or defend the action within the limitations of these provisions. 92A, the pleadings allowed are complaints, answers, cross complaints, answers to cross complaints, and general demurs. B, the answer need not be verified, and even if the complaint or cross complaint is verified. Interesting. Okay, that's interesting. Interesting to know. If you're in a limited civil case and you file a verified complaint, the answer does not have to be verified. Special demurs are not allowed. Motions to strike are allowed only on the ground that the damages or relief sought are not supported by the allegations of the complaint, and except as limited by this section, all other motions are permitted. Okay, so limited civil cases have limits to motions, i.e. motion to strike and no requirement that answer is verified. Answer is verified. All right, 93. A, the plaintiff has option to serve case questionnaires with the complaint using forms provided by judicial counsel. Questionnaire shall include a completed copy of the plaintiff's completed case questionnaire. So I think the reason why they're saying questionnaires is because that's what that means, is rather than interrogatories. But and the questionnaires are from the judicial council. Like, they're not like specially written questions. So the questionnaire served shall include a complete copy of the plaintiff's completed case questionnaire and a blank copy of the defendant's case questionnaire. Any defendant upon whom a case questionnaire is served shall serve a completed defendant's case questionnaire upon the requesting plaintiff with the answer. The case questionnaire shall be designed to elicit fundamental information about each party's case, including names and addresses of all witnesses with knowledge of any relevant facts, a list of all documents relevant to the case, a statement of the nature and the amount of damages, and information covering insurance coverages, injuries, and treating physicians. Do they really call that evidence? No, the nature of those things. The judicial council shall design and develop forms for case questionnaires. So it's prejudicial to consider insurance coverage when deciding when you go into court. The evidence code disallows it, but the evidence code relates to evidence in court. It doesn't relate to discovery. So all of these things can be discovered. D, approved forms shall be made available by the clerk of the court. E, if the party on whom a case questionnaire has been served under subdivisions A and B fails to serve a timely or complete response to that questionnaire, a party serving the questionnaire may move for an order compelling a response or a further response and for a monetary sanction under Section 2023. If a party then fails to obey an order compelling a response or a further response, the court can make those orders that are just, including the imposition of an issue sanction, an evidence sanction, or a terminating sanction under Section 2023. In lieu of or in addition to that sanction, the case may impose a monetary sanction under Section 2023. What's 2023? What is Section 2023, Alex, for 1,000? We gave the title and part and division of everything else except for civil, limited civil. It applies to limited civil cases. So it actually applies here. And we just refer to it as Section 2023. Okay, so that means maybe it's part of the Civil Code of Civil Procedures. All right. 93A. So we got a lot more to read. 93A. A plaintiff has the option to serve case questionnaires. I really don't care about these case questionnaires. With a complaint using forms from the Judicial Council, the questionnaire shall be included in the completed copy of the plaintiff's completed case questionnaire and the blank copy of the defendant's case questionnaire. B, any defendant upon whom the case questionnaire is served shall serve a did I just read this? No, it didn't. Any defendant, they're going to give it to the requesting plaintiff with their answer. C, the case questionnaire shall designate to elicit fundamental information about each party's case, including names and addresses of all witnesses with knowledge of any relevant facts. Right, we just talked about that. The nature of amount of damages, etc., insurance coverage, injuries, treating physicians. D, approved forms shall be made available by the clerk of the court, obviously developed by Judicial Council. E, if a party on whom a case questionnaire has been served under this doesn't respond timely, then your order compelling response, you move for an order compelling response and possible money sanctions under Chapter 7, and that's of this section. It actually tells me where we're going now. Chapter 7, Section 2023-10. So this is in Chapter 7, probably, of the CCP. I don't know that, but it's 2023 again. Title 4, Part 4. If that party fails to obey the order compelling the response, the court may make those orders that are just, including the imposition of the issue sanction, evidence sanction, terminating sanction. In lieu of or in addition to that sanction, the court may impose a monetary sanction. It gives the same citation for that authority. 94. Discovery is permitted only to the extent provided in this section and Section 95. The discovery shall comply with a notice and format requirements of the particular method of discovery as provided in Title 4. This is Section 2016 this time, 0.010 of Part 4. As to each adverse party, a party may use the following forms of discovery. Any combination of 35 of the following: interrogatories, demands to produce documents and things, and requests for admission with no subparts. It's giving the citation for all of these things. Like interrogatories come from Chapter 13, 2030. Demands to produce documents or things under Chapter 14, Section 2031, and requests for admission with no subparts under Chapter 16, commencing in Section 2033. B, one oral or written deposition under Chapter 9, Section 2025, Chapter 10, commencing with Section 2026, or Chapter 11, commencing with Section 2028 of Title 4 of Part 4. For purposes of this subdivision, deposition of an organization shall be treated as a single deposition, even though more than one person may be designated or required to testify pursuant to Section 2025. What about a partnership? Any party may serve on any, which would be more likely. Maybe not. I don't know. Any party may serve on any party a deposition subpoena duces tecum, requiring the person served to mail copies of documents, books, or records to the party's counsel at the specified address, along with the affidavit complying with Section 1561 of the Evidence Code. Okay, so subpoenas duces tecum requires an affidavit from Evidence Code. And I don't know if that's a section. It looks like a section of California's Evidence Code. The party who issued the deposition subpoena shall mail a copy of the response to any other party who tenders the reasonable cost of copying it. Physical and mental examinations under Chapter 15, commencing with Section 2032 of the same Title 4 of Part 4, and E, the identity of expert witnesses under Chapter 18, commencing with Section 2034 of Part 4 of Part 4. I think, Title 4 of Part 4. I think this is overkill if it's less than $35,000, but my 95A, a court may, on notice motion and subject to the terms and conditions as are just, authorize a party to conduct additional discovery, but only upon a showing that the moving party will be unable to prosecute or defend the action effectively without the additional discovery in making a determination under this section. The court shall take into account whether the moving party has used all applicable discovery in good faith and whether the party has attempted to secure the additional discovery by stipulation or by means other than formal discovery. B, the parties may stipulate to additional discovery. 96A, any party may serve on any other party a request in substantially the following form. 2, attorney for, semicolon. You are requested to serve. Okay. So this is the actual language. You are requested to serve on the undersigned within 20 days a statement of the names and addresses of witnesses other than a party who is an individual you intend to call a trial, a description of the physical evidence you intend to offer, and a description of the copies of documentary evidence you intend to offer, or if the documents are not available to you, a description of them. Witnesses and evidence that will be used only for impeachment need not be included. You will not be permitted to call any witness or introduce any evidence not included in the statement served in response to this request, except as otherwise provided by law. B, a request shall be served no later than 45 days or less than 30 days prior to the date first set for trial, unless otherwise ordered. A statement responding to the request shall be served within 20 days of the service of the request. No additional, amended, or late statement is permitted except by written stipulation or unless ordered for good cause on noticed motion. E, the request or statement served under this section shall be filed unless otherwise ordered. F, the clerk shall furnish forms for requests under this rule. And G, the time for performing acts required under this section shall be computed as provided in law, including sections 1013. So 96 is really important. Wait, do I have this in my thing? I totally don't. All right, all I have in my limited civil cases is written down is that it's less than $35,000. What need be included here is that Rule 95 through 96 relate to discovery, I think, and statements. That's kind of important. Sounds important. 97. Except as provided in the section upon objection of a party who served a request in compliance with Section 96, no party required to serve a responding statement may call a witness or introduce evidence except for purpose of impeachment against the objecting party unless the witness or evidence was included in the statement served. B, the exceptions to subdivision A are a person who, in his or her individual capacity, is a party to litigation and who calls himself or herself as a witness. 2, under B, is an adverse party. 3, witnesses and evidence used solely for purposes of impeachment. 4, documents obtained by discovery authorized by this chapter. And 5, the court may, upon such terms as may be just, including but not limited to, continuing the trial for a reasonable period of time and awarding costs and litigation expenses permit a party to call a witness or introduce evidence which is required to be but is not included in such party's statement, so long as the court finds that such party has made in good faith effort to comply with subdivision C of section 96, or that the failure to comply was a result of his or her mistake, inadvertent, surprise, or excusable neglect. I'm gonna write that down because I heard that recently. And I need to be able to talk in that language. Mistake, inadvertence, surprise, or excusable neglect. From section 473. From the sloppy section. C. Nothing in this article limits the introduction of evidence in any hearing pursuant to section 585. Number 98, a party may, in lieu of presenting direct testimony, offer the prepared testimony of relevant witnesses in the form of affidavits and declarations under penalty of perjury. So this is prepared testimony on affidavits and declarations under penalty of perjury. You want those words readily available too in your lexicon of legal language. The prepared testimony may include, but need not be limited to, the opinions of expert witnesses and testimony which authenticates documentary evidence to the extent the contents of the prepared testimony would have been admissible were the witness to testify orally thereto. The prepared testimony shall be received as evidence in the case, provided that either of the following applies. A and B are here. A copy has been served on the party against whom it is offered at least 30 days prior to trial, together with a current address of the affiant person providing the affidavit that is within 150 miles of the place of trial, and the affiant is available for service of process at that place for a reasonable period of time during the 20 days immediately prior to trial. B, the statement is in the form of all or part of deposition in the case, and the party against whom it is offered had an opportunity to participate in the deposition. The court shall determine whether the affidavit or declaration shall be read into the record in lieu of oral testimony or admitted as documentary exhibit. Rule 99, a judgment or final order in respect to the matter directly adjudged is conclusive between the parties and their successors in interest, but does not operate as collateral estoppel of a party or a successor in interest to a party in other litigation with a person who is not a party or successor in interest to a party to the action in which a judgment or order is rendered. And Rule 100, any party shall have the right to appeal any judgment or final order consistent with the law governing appeals. So I don't even know why we said anything that we said there, but that's fine. I don't know. Sound pretty typical. Didn't sound like extraordinary by any means. So that was limited civil cases. Small claims court. Just want to read the general, just like how much is involved here. It's like defining stuff. And it doesn't tell me at all how much needs to be in dispute, like the amount and controversy. Going. Except as provided in subsection C, E, and F for recovery of money if the amount of the demand does not exceed $6,250. Okay, so it's got to be less than $6,250, and clearly this number moves. All right, so somewhere, I think that would mean that limited civil cases lie somewhere greater than 6K and less than 35K. And then unlimited cases would be greater than 35K. And it might have been 25K when I took the bar. I don't know. The way these things move. Going back, because I don't care about small claims court, except I want to know about this motion to vacate appeal related matters, if it's not long. Oh my God, it's so long. It's really long. Why did I want to read that? Oh, no. Oh, I didn't even want to read that. I wanted to read satisfaction and enforcement of judgments. Let me see if my chick will read this. Oh my God. Weird. Vendredi. Isn't that contradictory? Didn't you just say the costs were gonna be charged for it, collected somewhere else? How does a prevailing party what is if they fail to give this acknowledgement, right? It's saying, I think they have to pay $50. Like, what? It's like a judgment is entered within 14 days after receiving a request and is liable to the judgment debtor for all the damages sustained by reason of the failure. So, okay, you got to acknowledge that you received. The judgment was satisfied within 14 days. But then again, who requests within 14 days after receiving the request? What request? I don't know. So then there's like, I don't really care much about what happens after satisfaction, but there's like, rebuttable presumption of full payment or partial payment, according to the next sections, whichever applies, is created if the judgment debtor files both the following with the clerk of the court, which is a canceled check and money order for the full or partial amount, and declaration saying that what they paid, but nobody filed an acknowledgement of satisfaction. I mean, I guess I understand why this has to happen, but debtor desires to make a payment to the court in which a judgment was entered may file a request to make a payment, okay, to avoid this from occurring. And accrued in interest and costs apply. The clerk remits to the judgment creditor. It's not a money order certified a cashier's check. They wait 30 days before they remit this money to the judgment creditor. I'm talking about the disposition of these costs and interests. If unpaid within 3 years, they probably get it sheeted because it's referring to the government code, and a fee of $20 shall be paid by the judgment debtor for the cost of administrating this section. They go into the vehicle sections, blah, blah, inclusive of the vehicle code. About $1,000 or less. Motor vehicle accidents. And suspensions of licenses and stuff. And so the rest of this all has to do with like suspension termination, suspension of a person's privilege to operate a motor vehicle. So we're done with small claims court. So section 6 is general provisions respecting the courts of justice. There's about 23 sections. I'm going to Article 1, open court access. See if I have to read this.
Code. Except as provided.
All right, they're defining remote access. Excuse me. Incidental powers and duties of the courts is the next section. Woo.
3, to provide to maintain respect. The execution of any of right
Blah, blah, blah. If an order of contempt is made affecting the victim of domestic. D, in addition to any award pursuant to a section for an action or tactic described in subdivision A, the court may assess punitive damages against plaintiff on the determination by the court that the plaintiff's action was an action maintained by a person convicted of a felony against a person's victim or the victim's heirs, relatives, estate, or personal representative for injuries arising from the acts for which the person was convicted of a felony, and that the plaintiff is guilty of fraud, oppression, or malice in maintaining the action. E, this section shall not apply to disclosures and discovery, requests, responses, objections, and motions. F, sanctions ordered pursuant to this section shall be ordered pursuant to the following conditions and procedures. One, if the notice and the reasonable opportunity to respond. Gonna skip. And determining sanctions. Seeing if a party seeking sanctions has exercised due diligence. A motion for sanctions under the section shall be made separately and allege the tactic in bad faith. If the alleged action or tactic or is the making or opposing of a written motion of the filing, service of complaint, cross complaint, answer, blah, blah, pleading that can be withdrawn and appropriately corrected. A notice of the motion shall be served as provided in section 1010, but shall not be filed with or presented to the court unless 21 days after the service of the motion or any other period as the court may describe as challenged action or tactic is not withdrawn or appropriately corrected, right? So that's consistent with the federal code of Federal Rules of Civil Procedure. If warranted, the court may award to the party prevailing on the motion the reasonable expenses and attorney's fees incurred in presenting or opposing the motion. Absent exceptional circumstances, the law firm will be held jointly responsible for violations committed by its partners, associates, and employees. D, if the alleged action or tactic is the making or opposing of a written motion or the filing in service of a complaint, cross complaint, answer, or other responsive pleading that can be withdrawn or appropriately corrected, the court on its own motion may enter blah blah, and it's frivolous and necessary delay, blah blah. 21 days of service. So you gotta call someone out and wait 21 days. 2, an order for sanctions pursuant to this section shall be limited to what is sufficient to deter repetition. So I have heard this all before. Subject A and B, probably above, a sanction may, or below, a sanction may consist of directives in non-monetary nature, penalties of the court imposed on motion and warranted for effective deterrence, and order directing a payment to the movant of some or all of reasonable attorney's fees and expenses as a direct result of the action tactic. Money sanctions may not be awarded against, so these are the exceptions to the full power that the court has, is monetary sanctions may not be awarded against a represented party for a violation. We knew that. Monetary sanctions may not be awarded on the court's motion unless the court orders its order to show cause before a voluntary dismissal. G, a motion for sanctions brought by a party or a party's attorney primarily for an improper purpose, such as to harass or cause unnecessary delay or needless increase in the cost of litigation. Needless increase in the costs of litigation shall itself be subject to a motion for sanctions. It is the intent of the legislature that courts shall vigorously use the sanction authority to deter the improper actions and tactics or comparable actions or tactics of other similarly situated. H, the liability imposed by this section is in addition to any other liability imposed by law or acts or omissions within the purview of this section. I, the section applies the sanctions or taxes that were part of a civil case filed on January 1, 2015. 128.7, every pleading, petition, or written notice of motion or similar paper shall be signed by at least one attorney of record in the attorney's individual name, or if the party is not represented by an attorney by the party. Each paper shall state the signer's address and telephone number, if any, except when otherwise provided by law. Pleadings need not be verified or accompanied by affidavit. An unsigned paper shall be stricken unless omission of the signature is correctly corrected promptly after being called to the attention of the attorney or party. By presenting to the court whether the signing, filing, submitting, or later advocating a pleading, petition, written notice of motion, or other similar paper, an attorney or unrepresented party is certifying that to the best of the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstance, all the following conditions are met, 1 through 4. 1, it is not being presented primarily for an improper purpose, such as to harass or cause unnecessary delay or needless increase in the cost of litigation. 2, the claims, defenses, and other legal contentions therein are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. 3, the allegations and other factual contentions have evidentiary support or, if specifically so identified, are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. And 4th, the denials of factual contentions are warranted on the evidence or, if specifically so identified, are reasonably based on a lack of information or belief. C, if after notice and a reasonable opportunity to respond, the court determines that the subdivision B has been violated, the court may, subject to the conditions stated below, impose an appropriate sanction upon the attorney's law firms of party or parties that have violated Section B or are responsible for the violation. In determining what sanctions, if any, should be ordered, the court shall consider whether a party seeking sanctions has exercised due diligence. 1 and 2 come after that. 1, a motion for sanctions under this section shall be made separate from other motions and requests that shall describe the specific conduct alleged to violate the subdivision. B,
Code.
no.
Section. Code.
Here.
complaint or petition filed after January 1st. Photograph. File for review purposes.
So no dead bodies. Right, right. Okay, that's enough actually, because we'll get to the very end and we'll still be talking about this topic. So that simply was incidental powers and duties of courts. And now we could go to judicial holidays. I mean, courts of justice may be held and judicial business transacted on any day except as provided here. That's 133, 134, except as provided in C. The court shall be closed for the transaction of judicial business on judicial holidays for all but the following purposes: to give, upon their request, instruction to a jury when deliberating on a verdict, to receive a verdict or discharge of a jury, for the conduct of arrangements and the exercise of powers of a magistrate in a criminal action or in the proceeding of a criminal nature, for the conduct of Saturday small claims court sessions pursuant to the Small Claims Act and Chapter 5.5 we just talked about. Injunctions and writs of prohibition may be issued and served on any day. And any superior court, one or more departments of the court may remain open in session for the transaction of business that might come before the department in the exercise of civil or criminal jurisdiction of the court, and both on a judicial holiday or at hours on day, night, or both, as the judges of the court prescribe. The fact that the court is open on a judicial holiday shall not make that day a non-holiday for purposes of computing the time required for the conduct of any proceeding or for the performance of any act. Right. So like service, for example, is still going to recognize the holiday, even if the court's open. Any paper lodged with the court at the time when the court is open pursuant to subdivision C shall be filed in the court the next day. That is not a judicial holiday if the document meets appropriate criteria for following. 135, any full day designated as a holiday by section 6700 of the government code, including that Thursday of November declared by the president to be Thanksgiving Day, is a judicial holiday, except the date corresponding with the second new moon following the winter solstice or the third new moon following the winter solstice should an intercalary month intervene, known as Lunar New Year, April 24th, known as Genocide Remembrance Day, September 9th, known as Admission Day, and the second Monday in October, known as Columbus Day, and any other day appointed by the president, but not the governor, for a public fast, Thanksgiving, or holiday. If the judiciary holiday falls on a Saturday or a Sunday, the Judicial Council may designate an alternate day for observance of the holiday. Every Saturday and the day after Thanksgiving Day are judicial holidays. Officers and employees of the court shall observe only the judicial holidays established pursuant to this section. 136, because that was not confusing. 136, if a day appointed for the holding or sitting of a court or to which it is adjourned falls on a judicial holiday, it shall be deemed appointed for or adjourned for the next day. Okay. Proceeding of case in absence of judge and seal of courts is the last part. So, and like we said, Chapter 7, the special immigrant juvenile findings. So I think that I can consider at this point, proceedings of the case in absence of the judge. If they're not, okay, this is short. If no judge attends, it's part 139. If no judge attends on the day appointed for the holding or sitting of the court, or on the day to which it may have been adjourned, within 1 hour after the time appointed, the sheriff, marshal, or clerk shall adjourn the same until the following day at 10 o'clock, and if no judge attend on that day before noon, the sheriff, marshal, or clerk shall adjourn the same day until the following day at the same hour, and so on from the day to day, unless the judge, by written order, directs it to be adjourned to some day certain, fixed in said order, in which the case it shall be so adjourned. Okay. And seals of courts. I'm just curious what that even means. Section 153, except as otherwise expressly provided by law. The seal of a court need not be affixed to any proceeding therein or to any document except to the following: a writ, a summons, and a warrant of arrest. That is going to be it for what? For part 1 of Courts of Justice, Title 1, Organization and Jurisdiction. And we're going to probably start in part 2 or title 2, chapter 8 in the next recording of California Civil Procedure.